How's it going, everybody? Welcome back to 2A News Now. And here at 2A News Now, you get your Second Amendment news straightforward and to the point with no BS added in. For the longest time, the ban-happy Democrats have referred to standard capacity magazines as either high capacity or large capacity magazines. And in certain cities and states, they have banned those magazines. Most of them have banned magazines that hold more than 10 rounds. But the 2A news that I'm going to give you today is something I have never heard of. A federal appeals court has denied a challenge to Washington, D.C.'s ban, not on large capacity or high capacity magazines, but what they call extra large capacity magazines. Like I said, I've never heard of that. 4 gun owners challenged that law. They said that they needed magazines that hold up to at least 17 rounds for self-defense. But in a 2-1 decision, the U.S. Court of Appeals for the District of Colombia ruled in favor of the District of Colombia. The 2 judges that ruled in favor of the ban were Senior Circuit Judge Douglas Ginsburg and U.S. Circuit Judge Patricia Millett and U.S. Circuit Judge Justin Walker, that voted in favor of the 4-man lawsuit. According to Washington, D.C. law, it's a felony to possess, unbelievably, what they call an extra-large capacity magazine. And they describe an extra-large capacity magazine as one capable of holding 10 rounds of ammunition. Isn't that absolutely ridiculous? The 4 gun owners that were suing the District of Columbia, their names are Eric Klun, Nathan Cheney, and I'm probably going to pronounce this last name completely wrong, Tyler Zaguire, and Andrew Hansen. Said they all own magazines that exceed the legal limits in the District of Columbia. And they said if they could, they would use them for lawful purposes. Of course, including self-defense, because they can't because that law was in effect. And according to the court, they applied the test when the Supreme Court ruled in the case of New York Rifle and Pistol Association versus Bruin to determine whether the District of Columbia's law against extra-large magazines falls within the nation's historical tradition of firearm regulations. The panel did reject some of the district's arguments. The 2 judges in the majority said mass shootings are a recent phenomenon, and they say that lacks direct precedent. But they pulled out of their asses that during Prohibition, the limitations that were put on Thompson submachine guns, sawed-off shotguns, and Bowie knives are similar in banning magazine capacities. They claim because those particular laws actually showed a tradition of regulating weapons that were capable of unprecedented lethality. So the court ruled that met the standard set by Bruin. And of course that's a load of crap. Judge Parker in part wrote in his dissent that any restrictions on arms for self-defense would be unconstitutional, and said that a blanket ban on arms in common use could not survive constitutional scrutiny. So it really sucks that the court didn't rule in favor of the 4 gun owners in the District of Columbia. But how in hell do they call a magazine that holds over 10 rounds an extra-large capacity magazine? What the hell is that? At first when I read this, I thought maybe they were talking about drum magazines, something that holds like 50, 75, or 100 rounds or more. But 10 rounds is considered an extra-large capacity magazine? They've lost their freaking minds. As always, I would really like to hear your thoughts about today's video in the comment section. And if you enjoy videos like this, and if you haven't subscribed to the channel, just take a few seconds and hit that subscribe button and join the over 61,000 subscribers to the channel. And also, if you want to help the channel out even further, besides subscribing to the channel, if you also like, share, and hit those post notifications, I would really appreciate it. And I invite you to come back and watch my next video.